Good morning, everyone. Thank you for joining us today. My name is Lorena Rodriguez. I'm the captain at Sheriff's Information Bureau. Today, Sheriff Villanueva will discuss false claims made in a recent lawsuit filed by a disgruntled employee. Now it is my honor to present the Sheriff of Los Angeles County, Alex Villanueva.
Morning, everyone. What we're going to do first is we're going to walk you through a timeline of events and kind of give you a primer on how the department does investigations and what works and what didn't work. Okay, so we'll walk her through from the starting point, which is March 10th of last year, the date of the incident in San Fernando Court, which you're probably already familiar with. You've seen the video, and then we'll work our way forward and bring you all the way up to the present, and then we'll pause along the way. Okay. Okay, March 10th, use of force incident involving the deputy of the San Fernando Court. You already know that. Video viewed by the area lieutenant, by the unit commander, and viewed by Conway Operations Assistant Sheriff and Court Services Division Chief, and Commander Castellano, who was the one who filed the complaint. So we know that happened on March 10th. March 19th, IAB received a notification 9 days later. And this is standard protocol in a use of force investigation. And this use of force was classified as a Category 2. To be Category 3 needs to be use of firearm, deadly weapons, broken bones, hospitalization, those categories. But this is classified as a Category 2. And Category 2 incidents really actually never rise past the level of Division Chief as per our reporting procedures. So March 24th, 14 days later, 2 weeks later, the use of force package is approved by the lieutenant. Then a day later, use of force package is approved by the captain. Okay? And then April 13th, the IAB case was open. This is internal affairs. Investigation was open. That's on April 13th. So it doesn't sound much like a cover-up here, as alleged. Okay, then we go. Now here's where there's a big gap in time. From the time it was approved by the captain to the next person up on the chain of command as a commander, there's about a 3-month gap. All right, and that is subject to why did it take that long. Then, from there, July 12th, use of force package approved by Court Services Division Chief, who has since retired. Okay? And then use of force package sent to Discovery Unit. This is a normal chain of events, notwithstanding the delay right here. But this is for all Category 2 uses of force. This is standard procedure for the entire department's operations. Custody, patrol, court services, the entire department. That is how it works. So the last authority in the signature line is the division chief. It doesn't go above the division chief in standard protocol. Now, moving on our timeline. I know we've kind of flipped it. We can't keep it going that way. But September 5th, Commander Eli Vera assigned to Court Services Bureau. November 18th, yes, this is the important date. This is the date that I was shown the video. The internal criminal investigation was opened. This is a very important date. So the question was, why was it not launched at any point prior to November 18th? And to launch this investigation, typically, it has to occur with the authority of division chief. It should never go above the division chief, because if it's above the division chief, the question automatically is going to be, what happened to the division chief? Then, of course, typically, it's a memo from the unit commander to the division chief recommending that a criminal investigation be initiated, or at least a consultation. So the criminal investigation unit can then make their determination, kick it up to the Justice System Integrity Division of the District Attorney's Office. That is how it happens by protocol. And this is well established. So this is where it gets weird, because it never happened prior to November 18th. And there's no memorandum, there's no documentation at all in the entire case file of a lieutenant, captain, commander, or division chief signing a memo until after this date. And what happened on this date, Kelly Porowski, who has since retired, she actually was notified in person by the undersheriff to write to make that happen. She was in charge of Professional Standards Division, and she knew exactly what was missing. Where is a memorandum from the concerned division chief? So on November 22nd, right here, actually they opened up two things. But let's go here. Before we get into that point, on this same day, order was given to relieve the deputy of duty. The very next day, the individual involved, the deputy, takes a leave of absence. And he's gone all the way till December 6th. So the first day he returned to work, he was relieved of duty, which was on December 7th. All right. So now, when we're at this point forward, we're becoming aware of the entire situation and what was handled at the division level, and we have a lot of concerns. And that prompted us to open another IA investigation, which has since concluded. And that was about the handling of this and the failure to open the ICIB. And there was two individuals, notwithstanding the complaint or the lawsuit filed by the commander, there was actually two people, not just one, okay? And this is supposed to be, actually it's a captain, not commander. They repeated that. That's a captain right there. So there's two individuals that are subject to this investigation. Okay, so as we're going through this, you can see that the complaint filed by the commander is not really lining up, but there's a lot more. Okay, now, as I said here, relieved of duty on December 7th. And then, mysteriously, when we want to start talking to people, then people start going on vacation and they're gone. Okay? So he has not returned to work since. Second subject, notification, this is the captain. And also the division chief takes a leave of absence and has since retired. Okay, now let's go to the next timeline. Now, Commander Vera also takes his leave of absence and then retires. So these are the people that we want to speak to, but now we can't speak to. Okay, March 8th, that second IA was concluded, with the appropriate action was taken with the commander and with the captain. All right, and that is documented. Now, he waived his, there's a Peace Officer Bill of Rights that has a lot of privacy issues built in to protection of personnel records of peace officers. However, when he filed his lawsuit and made it all a public document, he pretty much waived his right to privacy to this particular case. Okay. Now, this is where it gets really fun. Because right here, somewhere around here, in March 25th, March 26th was my campaign kickoff. But this entire week, it was one after another. It was a hit parade from the LA Times. And let's see here. Then we have here, and that was the first article. Actually, this is the third article in 1 week. Countywide Operations Assistant Sheriff appointed the rank of captain. Court Citizen Chief announces retirement, 3/31. April 14th, original use of force case presented to the District Attorney, the Justice System Integrity Division. So when it comes to cover-ups or whistleblowers, I don't exactly see what was covered up or what whistle was blown, because that's a mystery. All right, so now, April 27th, which is obviously, today's the 26th, right? 27th, tomorrow, this case is going to be represented to a third-party law enforcement agency with investigative authority. And they will be presenting all these facts that we have to date. So now let's go. That was that week of March 25th. Inspector General identifies 41 sheriff's deputies who allegedly belong to gang-like groups. This information is a year old. It's stale. They were sitting on it. And there's absolutely no actionable information on here for anybody. But it made for a good clickbait for the LA Times. Go to the next one. Here's another one. LA County panel launches investigation deputy gang. More clickbait. No authority to appoint anyone to give their subpoena power to, and they got pro bono attorneys. So more clickbait. Go to the third one. And here's the one. Right before, this is on Friday. Fearing bad publicity, LASD covered a case of a deputy who knelt on inmate's head. Well, this is a false headline right there. No, there was individual within a division they'd engage in something that was of concern. But they were not definitely acting on behalf of the department. That's for sure. Go to the next one. But watch how many bites at the apple our El Segundo Times is going to get. Oh, did I say that? LA Times. Okay. Go to the next one. Oh, I backed up one. Back up one more. Okay, we got that one. Notice here, actually back up again to that one. And some of the big highlights of that article. Eli Vera, commander of overseas court service where the incident occurred, said Villanueva viewed the video at an aide's desk within days of the incident. Vera is running against Sheriff of Villanueva and is retiring next week. Okay, and then of course, here's our dear friend Max Huntsman. Under ordinary circumstances, I would expect the Sheriff's Department to have prosecuted this case. And good question. Keep going. Sheriff Villanueva launches criminal investigation into the leak. Okay? And right away, the Times is trying to paint this somehow retaliation against whistleblowers, a chilling effect. Actually, quite the opposite. Keep going. Then we have, now if you count it, this is the fourth article. Files lawsuit. See? Then go to the fifth one. And then, and this is our claim from Commander Castellano. Directed cover-up of deputy kneeling on inmate. Okay, and apparently I read through the entire lawsuit, and let's see here. Let's go to the next slide. Okay, when we launched our criminal investigation, these are the crimes that we're looking at, because remember, what was taken from the department was an active criminal case. All right, so when two or more people conspire to engage in any of the conduct described below, that's a conspiracy. Burglary, entering a building to commit grand or petite larceny, or any felony. 502, unauthorized access of a database. 503, fraudulent appropriation of property by a person to whom it has been entrusted. Like case files, videos that belong to active criminal and admin investigations. Breach of public duty, this is California, and then a federal one, Title 18, U.S. Code, Section 1030, prohibits the unlawful access of a computer database in the excess of one's previously granted authority. So we have all these things that are obviously the subject of the criminal investigation, and this is not a leak, this is actually obstruction of justice. Go on to the next slide. So here are the three individuals that we want to know a lot about. This person said he gave it to this person. This person is actually authorized to receive the completed investigation. But somehow it landed in the hands of the third person, the reporter from the LA Times. So now the question is, when did this happen? That's a very important question. So these three people have some important questions to answer. When did they do this? So the three standard questions in any corruption cases: what did you know, when did you know it, and what did you do about it? So since everything was being investigated, what exactly was the whistleblowing? So, and then again, remember that LA Times explosion of things right up to when I launched my campaign in that March? That was a pièce de résistance right there, the day before. Okay, go on to the next slide. Okay, now this is Mr. Castellanos' own report. This is his writing, and we highlighted this. According to Lieutenant Hernandez, Captain Jacqueline consulted with Custody Investigative Service, and it was determined. That is not the testimony of Lieutenant Hernandez, and that not his report either. This whole third person, it was determined the case should not be filed given the misconduct, unreasonable force allegation, and the potential for the incident to shed negative light on the department. That is entirely authored by Commander Castellano, who then elected not to initiate a criminal investigation. And he had three different captains went through that Court Services West Bureau, and all three of them did not produce it, and he never required or asked for a criminal investigation to be initiated. It's done in writing. Neither did the division chief. So this entire thing, you never write something and it was third person. This is never heard of before, especially on a use of force. Go to the next slide. Again, we get this famous, a decision was made by an executive above the division chief. Who writes something like that? Again, talking to Lieutenant Hernandez, his testimony in the interview, he did not say that. That was a product of Mr. Castellano.
Chef, I'm sorry, when is this from and what document is
This is the use of force on the case from the San Fernando court, which is the subject of now the lawsuit. Okay, go to the third one. And this is Mr. Castellano's signature, where he says an admin investigation was ordered and completed for this incident, referencing this number. This is not true. That admin investigation has not been completed, yet he signed it. Okay? We cannot complete this admin investigation until we complete the criminal investigation. Once we know the results of the criminal, then we can go back and we can get compelled statements from the subject on the administrative investigation. That's the proper order of events. So what he was signing for here is a mystery to me. All right, and the fact is, this would have remained within the division and gone for filing at Art Records Risk Management Bureau. It never would have seen the light of day again. All right. Go further. Now, Mr. Castellano and I actually was his subordinate when I was a lieutenant at Pico Rivera Station. And if you recall this incident, Top LA County Sheriff's official, that was Mike Rothen right there, was driving around in a stolen car, a 2012 Audi. Okay. What does it have to do with Mr. Castellano? Actually, quite a bit. Because the vehicle was purchased from someone owner of Vernola's Tow from Pico Rivera, which is a contracted towing firm. And Mr. Castellano was a captain of Pico Rivera at this time. When this case came to light, he was never criminally prosecuted. Never. And the main reason why he wasn't prosecuted criminally, because they could not establish the value of the vehicle. He alleged it was all banged up and beat up. So he bought a vehicle that was 2 years old for $3,000, an Audi. And of course, there's a document called a CHP 180, which is what you fill out when you tow or impound a vehicle or store a vehicle. And part of that, the person who's doing the towing or the impounding fills out a description of the vehicle, the value of the vehicle, and any major damage or anything like that. Mysteriously, under the command of Mr. Castellano, Pico Rivera, that document disappeared. I could pull 1,000 other CHP 180s during that time period and find every single one, but that one in particular could not be found. So he retired overnight, Mr. Rothens. So there was no criminal prosecution, no attempt to do a criminal prosecution. Go on. Yep, that's him right here. And he was promoted subsequently to the rank of commander. Don't know why. And this gentleman right here, Mr. Huntsman, wrote a 7-page report and filed it as confidential. It was not made public. Unlike all of the documents he produces during my time as sheriff, for some strange reason, this one was made confidential. We dug it up, and it was a whitewash like no other. So the question is why? So what's the relationship between these three people? That's of concern. So when it comes down to credibility, well, you be the judge of that. Go one further. And this is the favorite part. I'm going to the lawsuit on page 4. And remember, according to his big theory of this attorney, that I had a seething rage about Commander Castellano, and I conspired to basically retaliate against him. But this is pretty funny, actually. As a lieutenant, Villanueva mishandled an incident with an inmate and violated department policy. Villanueva failed to get needed medical aid for an inmate who had been tased by a deputy. And he goes on and on about this, and then the fun part is Villanueva, in late 2016, Villanueva was provided with a notice of intent for discipline with a 5-day suspension. And then, that I lied in this case, by the way. He claimed that I had said that I had given him permission to violate. He had given me permission to violate department policy. What happened was an inmate in the booking cage at Pico Rivera Station, just out of the blue, just started wailing on another inmate and assaulted him. So the people work in the jail, I think they ended up pepper spraying him. They ended up tried to tase him once. It didn't work. One of the barbs didn't stick, and so the tasing was ineffective at all. The inmate pulled the barb out himself and said, basically, "Come get me," if I recall the incident. So he was subsequently subdued, handcuffed. Paramedics came, they checked him out, all his vitals, and the question was, and he was really wanted to have his handcuffs removed. We could have taken him to a local hospital and then have a fight at the local hospital, or we could safely take him to the jail and have him seen at the jail. I chose the obvious choice, which is take him to the jail, which is a secure location, so he could be treated there for any potential injury from the barb. And policy says you have to have him cleared medically. But I was not going to take this gentleman in that state of prone to violence to a local hospital, then have to fight him in a hospital. So I did the obvious thing, made a command decision to say, hey, we're going to take him straight to jail where he can be treated there. He's already been screened by the paramedics. And we have a policy that says you have to try to avoid force. So I had two competing policies here. One that says take him to the hospital. The other one says avoid force. So I went with a common sense approach. Let's avoid force. Let's get him the care he needs in a jail setting, hospital setting, not in an open hospital where there's a lot of problems that can go very bad. And so I told Mr. Castellano this. This is on a weekend, and I phoned him. And during the interview, this is my case, he says that he never called me, or I never called him. Of course, when we produced the phone records, then he said, oh, well, I must have misspoken, I forgot. So I didn't call him on the weekend to ask him, a barbecue recipe. I called him to report about what I did and just wanted to let him know. And he should have been a subject of investigation subsequent to this. But this is a previous administration where command staff was never faced with any type of discipline. Another example of it. So I ended up getting a written reprimand, and I served it on March 1st of 2017. I retired a year later. But now he's claiming that I delayed the imposition of discipline and proceeded to retire to avoid the suspension in 2018 before the discipline was finalized. After Villanueva was elected sheriff later that year, he moved quickly to conceal evidence of the pending discipline and restricted the IB investigation from LAC computers. This is a copy from, we burned this yesterday. This is on our PRMS system, Personnel Record Management System. Is that what it stands for? And is there. All right? So the foundation of this entire lawsuit is false. Everything on this lawsuit is false. And when you take this entire, I'll go to the next one. When you take this entire thing into context, you realize that there was a lot of people working in concert and coordination. That includes the LA Times. That includes people that obviously want to defeat me electorally. That includes the board-appointed Inspector General and the Civilian Oversight Commission. A lot of people working overtime, and they're doing it as best they can, so there'll be more of this nonsense thrown at me until June 7th, but it is what it is. But we're more than excited to actually have to testify under oath in any court of competent jurisdiction on this matter in front of a grand jury in a federal court. In fact, we're more than excited to, and every single member of my command staff will sign a sworn affidavit to that effect. And I can tell you right there, there's George Valdez in the back. I have Commander Satterfield, and I have Captain Tony Blanchard, and they're more than happy to testify to this matter. So notice how we're not using unnamed sources or multiple sources. They're real people. They're doing real work on this department. We don't have time for this internal, let me see if we can blow up the sheriff somehow nonsense. We have serious issues to handle out there. We have violent crime. We got homelessness out of control, defunding, and on top of that, I have this circus is entirely orchestrated for political purposes only. And too bad I don't have people, reporters like from the LA Times. Maybe you need to start clarifying exactly what you did with this and who did you get it from, and when did you get it? So that's a question for you to answer. So with that, we're not going to take a question from you. Anybody else has a question?
Sheriff, can I ask you a question?
Go ahead, Frank.
Is Aileen from the LA Times under investigation by the department?
The matter is under investigation. All right?
Is she under the
The
investigation?
matter is under investigation. This is stolen property that was removed illegally from people who had some intent, criminal intent, and it'll be subject to investigation. We will not be the only party investigating this. There will be other agency will also be thoroughly investigating this and monitoring what we're doing. And it will be handed over to the appropriate prosecutorial agency so they make a determination.
Sheriff, are you going to answer the question? You placed your picture up there
Mm-hmm.
alongside two other people, and you talked about it in terms of a criminal investigation.
Mm-hmm.
Is this Los Angeles Times reporter under investigation by the department?
Well, the act is under investigation. All parties to the act are subjects of the investigation. Now, that's why we do investigations. We don't just walk away and say, oh, well, oh, well, so sad. No.
Is she one of the parties?
Well, she received the information and then she put it to her own use. What she receives legally and puts to her own use, and what she receives illegally and or the LA Times use it, I'm pretty sure that's a huge, complex area of law and freedom of the press and all that. However, when it's stolen material, at some point you actually become part of the story. So that's up to the LA Times to decide that. Sir.
You should definitely answer the LA Times questions. I think we'd all agree with that here, but that's up to you.
Mm-hmm.
So in that timeline, sorry, I was just a little bit confused. So when did you see the video for the first time?
November 18th.
And that, seeing it and being aware of it, is that the same thing?
Yes, actually.
November 18th.
Not only did we see November 18th, we took immediate action, and that's what launched the criminal investigation that for some reason eluded all these players from March 10th all the way to November 18th, which is what all the critics can't really explain. Why?
And what about the undersheriff? When did he first see it?
That very same day, he was made aware as well.
Yeah, Sheriff, can the undersheriff comment, because the claim says that the undersheriff was in the room with you on on or around March 15th when the DVD was viewed, so I'm curious if Undersheriff Murakami would comment on whether that allegation was true, because they're saying that he was a witness to you seeing the video in March.
Well, I'll tell you this, and he's free to answer that question, but I'll tell you, see, when you say they, give me a name.
I'm saying that's in the claim from Castellanos.
Right. And again, Castellanos was not there either. All of this information on the claim is literally third party and anonymous. And
So can Murakami weigh in?
Yeah, the question is, when did I see it? The claim in March is false. I don't know where they got it from, but it's not true.
So you're saying that meeting in Villanueva's office never happened with the DVD, and Limon was the other person in the room?
No,
And
never happened.
Blanchard is also here. Anthony Blanchard, can we hear from him as well?
No, I never saw the video. Up in the mic, please.
No, the video was never seen in March the way it was presented.
So, Sheriff, your timeline completely ignores the fact that the paperwork filed in this case in July very clearly says the case was elevated above the division chief. And that could be no, let me finish my question, please.
back it up. Let's go up there. There you go. Okay.
Look, can I finish my question? So that could only be you, Under Sheriff Murakami, or Robin Limon, and his claim suggests, Castellanos' claim suggests that it wasn't Robin Limon, which leaves you and Murakami. So somebody is lying in this case. Is it you guys, or is it all of the people that he cites in his claim and all the emails?
Define all the people. Put names to it.
Let's pull up the.
Well, let's start with this. Let's make it real obvious to you. That is a claim
Robin
from.
Limon, Lieutenant
Wait.
Hernandez.
That is a complaint from Mr. Castellano. All right? That's his claim.
Right.
Commander Vera, who was also, strangely, a commander in that very same division who did not also ring the bell when he had the opportunity to. They're making a claim, but they don't have any facts to support their claim. The claim of itself means absolutely nothing. When I have 4 people, and I'm not going to go into the details of what we have, but we're really happy to share them at the worst time possible for the people making this complaint.
Was Robin Limon interviewed as part of any internal investigation about what she
As
knows?
we indicated She was not interviewed, and she elected to take a leave of absence, so she's not available to be interviewed. Yes, they're very convenient. Exactly.
Also, you usually decline to comment on pending litigation, but today we have a whole news conference and a timeline. Can we expect this standard for all lawsuits filed from here on out?
No, only when the LA Times goes out of their way to try to put false allegations and make a whole campaign, you will get what we normally shouldn't have to do, and we let the lawsuits speak for themselves, and we'll go through the process and we'll defend them vigorously. We also found something else pretty interesting. A lot of our battles now is to actually get competent, independent defense, which we're not getting, because the people that are assigned to defend us are actually working on behalf of the Board of Supervisors. So we get, I guess you could call it the Matador defense when it comes to legal representation. So we have to now go out of our way to get our own defense. Hold on a second. Over there, sir.
Just real quick, can we go back to the first slide? I just was a little confused about the timeline initially. Because it happened on March 10th,
March 10th.
and then March 19th, did you say you were emailed about it?
No. You got to remember, the IAB was notified. Whenever you have a Category 2 use of force, there's always notifications made as part of the matrix. There is no notification, hey, let's call the top guy on the department. There's 18 or 17,000 employees now. There's 12 different divisions. Every division is supposed to handle internally their use of force investigations. When there's an area of concern that arises, well, if it fits in the matrix, well, you make the automatic IA notification. If there's criminal conduct or potential, you're supposed to also make the notification to ICIB. This is what did not happen, and it should have happened on this very same day. And this is why did it take all the way to November 18th when we saw it to make that happen?
There was also some confusion too that,
Huh?
there was some confusion too, because initially you said November, then it was switched to October when you found out.
No, what happened when someone said October, that was someone from SIB, Sheriff's Information Bureau, that just guesstimated roughly when, but they were not speaking with the actual facts.
It's my information that actually ICIB was consulted before the November 18th date.
Well, you have better information than we do. We have our information, and we have it very well documented. It happened November 18th and afterwards.
No more questions.
What are the other agencies,
Okay.
what other
the rush?
agencies
What's the
involved
rush?
in the criminal investigation?
Oh, wait, we can.
Spanish.
Let me switch to Spanish real quick, because I know there's some people here want. Preguntas en español.
Sí, podemos sumarizar el timeline, podemos sumarizar el tiempo.
Sí, el incidente ocurrió el 10 de marzo. El 19 de marzo los investigadores administrativos fueron notificados. Entonces, hay un reporte entero del uso de la fuerza que se empezó y se terminó en 2 semanas, el 24 de marzo. Y el teniente lo aprobó. El capitán lo aprobó. Entonces, hay un tiempo, casi 3 meses, hasta que fue aprobado por el comandante, el que está haciendo la demanda. Y esta demora de casi 3 meses no se explica. Pero en todo este tiempo, la información ya se supone que estas personas hubieran hecho una notificación para iniciar una investigación criminal y nunca lo hicieron hasta llegar hasta aquí al 18 de noviembre, cuando yo tuve la oportunidad de ver el video por la primera vez y mi comandante, mi jefe de división, el capitán, nos enteramos de la situación y entonces en ese punto se inició la investigación criminal y también se le quitó de su posición trabajando durante el transcurso de esa investigación. Todo eso comenzó el 18 de noviembre y todas esas personas que están haciendo estas querellas falsas no tienen nada que decir porque nada se inició en todo ese tiempo hasta que nosotros nos enteramos.
Según los reportajes del LA Times, según la demanda, dicen que usted vio el video antes, ¿cierto?
Eso es totalmente falso. Eso el LA Times lo sabe, pero su interés es destituirme de mi posición y ellos están haciendo una campaña muy intensa en contra de mí, porque mi inicio de mi campaña de reelección fue el 26 de marzo, del 22 al 25 era uno tras otro, y por eso te enseñé todos los títulos, y todos son ¿cómo se dice? Noticias viejas o no tienen sustancia.
Si nos podría dar, por favor, los nombres de las personas que acabaron de hablar y están apoyando, diciendo que esa reunión no existió.
Sí, el subalguacil Tim Murakami y jefe de edición Jorge Valdés allá. Mi comandante, que es mi asistente principal, ese es John Satterfield. Y mi asistente capitán, y aquí está Tony Blanchard.
Usted decía que están dispuestos pues, a ir hasta la Corte Federal.
Todo. Vamos a hacer absolutamente todo. Tenemos los datos, tenemos la evidencia y todo eso es anónimo. Que si otra persona, una tercera persona dijo eso y lo otro, o sabemos, como dice la periodista esta, que le falta la integridad. Tengo recursos múltiples que dicen que esto ocurrió. No, nosotros tenemos las personas y tenemos las fechas y tenemos la evidencia de cuándo ocurrió y qué es lo que hicimos cuando nos percatamos de la situación.
¿Qué es lo siguiente que se viene ahora?
Bueno, mañana vamos a tener una reunión con otra agencia grande que ellos se dedican a investigaciones y vamos a darle toda la información que tenemos hasta el momento y vamos a coordinar con ellos para seguir con esa investigación con los elementos criminales porque todo esto fue un robo de un caso activo.
Dijo usted que van a demandar por robo de información. ¿Cuál es el cargo y quiénes están involucrados?
No vamos a hacer demandas, estamos en una investigación criminal y los cargos son el abuso abuso criminal, acceso criminal de información y lo que llaman en inglés embezzlement. Cuando tienes propiedad que se confía en usted de usar esa propiedad como se supone y después lo malapropias para hacer otro uso para ellos, un uso que es ilegal, eso es un crimen en sí. Entonces, acceso ilegal, algo que ya no tienes acceso, también es un crimen federal. Hay varios diferentes niveles de crímenes. Hay uno del estado de corrupción, cuando un oficial público comete algo que defrauda al público, por ejemplo. Ese es el código del Government Code. Hay muchos diferentes cargos y cuando hacemos la investigación, si se determina que nadie hizo un crimen, pues sí, pero como sabemos que el crimen ocurrió, ahora es saber quién fue el responsable y cuáles fueron los motivos y cuántas personas implica esto.
Sheriff, since you are disputing my reporting,
Sorry,
I'd
no more
like to
questions?
request.
Thank you.
No more questions.
Wait,
Thank
what,
you.
what other
No.
law
Can we
enforcement
ask you about
agency is
ALADs?
involved
Could
in
we
Thank you.
this
No more
questions,
questions?
sir?
Wait, he wants to...
Can we ask you about
So
I know
there
you
is
guys
another
want.
question.
You wanted to ask about ALADs, because from this point forward, we got an active 2 different investigations going on, so we can't comment further other than what has already been put out publicly, so we have to restrict it to that. But you had a question about ALADs.
One case is at JSID right now.
Yeah, and that's true.
Which one?
That's the one with a deputy on the use of force, the original one.
Is he still off duty?
He's still in a relieved duty status, yes. No,
Was it true that he was the subject of a criminal investigation on March 9th, Deputy Johnson, for a separate incident?
We have no information on that.
Involving
No more
illegal
questions.
gambling,
Thank you.
ALAD.
prostitution.
Thank you.
Yeah, okay.
Go ahead, Frank.
By the way, was Escalante ever charged?
ALAD's question.
Oh, yeah. React to ALAD's endorsement of you, please.
Well, 86% of their members, I'm happy with that. I think it speaks for itself. All right.
Thank you so much.
Thank you very much.
Thank
All
you
right.
very much.
Thank you. You got it?
Yes, I need your mic.